Welcome to this section of the Restoring America seminar. In part one of this section, we've been talking about how the Supreme Court of the United States and other federal courts have, just since World War II, literally been reversing the Founding Fathers' intention about this issue of the so-called separation of church and state. We've examined the evidence that the Founding Fathers were crystal clear about the fact that the Christian faith was supposed to influence matters of government and public policy in America. But you know, folks, the evidence since the founding period also reveals that Americans had continued to believe after the founding period that the Christian faith was supposed to influence matters of government and public policy. Why? Because as we saw, Washington addressed this in his farewell address. He said, if the sense of religious obligation desert the oaths that are used in courts of law, then that person has no sense of being held in judgment by God for what he or she is about to say on the witness stand. That has been throughout America's legal system, legal history, the understanding of so many of the judges in our courts. Justice Joseph Story on the U.S. Supreme Court in the 1800s wrote his famous Commentaries on the Constitution, published in 1833. Now, this was required reading by law students for about 100 years in America. Story saying, it's doubtful whether free government can survive when the state will not encourage public worship or the support of religion. Now, the United States Supreme Court in 1892, in a court case called Holy Trinity versus U.S., the Supreme Court had spent 10 years prior to 1892 examining documents from American history to see about the presence of God, the influence of the Christian faith. The decision of the U.S. Supreme Court was unanimous. Quote, no purpose of action against religion can be imputed to any legislation, state or national, because this is a religious people. And then they added this, our laws and institutions must necessarily be based upon the teachings of the Redeemer of mankind. It is impossible that it should be otherwise. And in this sense and to this extent, our civilization and our institutions are emphatically Christian. This is historically true. From the discovery of this continent to the present hour, there is a single voice making this affirmation that this is a Christian nation. We are founded, listen to this, this blows your mind. We are founded to legislate, propagate, and secure Christianity. So when the modern Supreme Court of the United States tells the American people that previous courts did not favor the Christian religion, that is an outright lie. Now, on an encouraging note, in the face of all this modern negative evidence from the courts, listen to former Chief Justice William Rehnquist. Quote, there is simply no historical foundation for the proposition that the framers of the Constitution intended to build a wall of separation. There is overwhelming evidence that all the founders meant by that was that we not establish a national church as was found in England. There is statement after statement, even from the constitutional notes themselves and all sorts of other people who were involved with it, that that is what was meant. He's absolutely right about that, of course. And then he said, it is impossible to build sound constitutional doctrine upon a mistaken understanding of constitutional history. The wall of separation between church and state is a metaphor based on bad history, a metaphor which has proved useless as a guide to judging. It should be frankly and explicitly abandoned. That is from former Chief Justice William Rehnquist. Now, the question remains, a question many people are very curious about. How in heaven's name did this perversion of the Constitution by the modern Supreme Court happen? How did this come about? Well, I've looked into it and I've found out how it happened. After 1900, what happened is that Darwinian thinking began to influence the study of law. Now, Darwin's Origin of Species was published in 1859, just prior to the Civil War. And of course, Darwin's Origin of Species puts forth the theory that human beings are evolving from something lower into something higher all the time. Folks, when God is rejected as the author of law through Holy Scripture, then there are no longer any objective standards of law. It's whatever floats your boat. So if God is no longer accepted as the author of law, then man must be the author of law. And in Darwinian thinking, since man and society are continually evolving, then obviously the laws must continually evolve as well. I mean, that's perfectly logical, right? So judges, through their decisions, guide the evolution of law in this way of thinking. So in order to study law, you study the decisions of judges, not the Constitution. They're talking about this idea that the law has to evolve because we all know that mankind is always evolving. You see, it's this kind of thinking. Now, this was introduced into Harvard Law School in the 1870s by Harvard Law School Dean Christopher Columbus Langdell. Langdell started the case law study method, studying the decisions of judges, in other words, instead of the Constitution. So law students really began to not study the Constitution anymore and to focus on studying the decisions of judges. By the 1930s, about 60 years later, this had spread to all law schools throughout the country. And Blackstone's Commentaries was the major teacher of law students on both sides of the Atlantic for many decades. Blackstone's Commentaries reveal that English constitutional law and common law is just completely rooted in Holy Scripture. Our American legal system, based in Holy Scripture, comes to us through English common law and English constitutional law, and Blackstone was the great teacher of this. His commentaries are full of Scripture references all over the place. But by the 1930s, Blackstone's commentaries were discarded. Now, men who embraced this philosophy, that is, of the law evolving, were appointed to the Supreme Court. Oliver Wendell Holmes, Jr. was an utter disaster as a federal judge. He was appointed to the Supreme Court of the United States in 1902. He said, quote, listen to this, "The justification of a law for us cannot be found in the fact that our fathers have always followed it. It must be found in some help which the law brings toward reaching a social end." Whew, here we go. What's that called? It's called the end justifying the means. I mean, this is just deadly awful. What Oliver Wendell Holmes is pushing here is the idea that if you have a social agenda, then you fix the law to accommodate that agenda. This is exactly what's been happening throughout the entirety of the 20th century in America with increasing frequency and now into the 21st. Earl Warren was appointed Chief Justice of the United States Supreme Court in 1953. In Trope versus Dulles, a decision in the year 1958, Earl Warren said, quote, "The constitutional amendment, the First Amendment that we're talking about here, the one that has this supposed separation of church and state, must draw its meaning," listen to this, "the amendment must draw its meaning from the evolving standards of decency that mark the progress of a maturing society." No longer is the First Amendment anchored in the original meaning and intention of the words, according to the Founding Fathers. No. Now it's unhooked and it's floating with whatever these evolving standards of decency are in society. So now we have the Supreme Court erecting standards pragmatically, which in the words of Chief Justice Rehnquist is neither principle nor unified. Now, the court these days tries to use Thomas Jefferson and James Madison to support this perversion of the Constitution they're engaged in, but listen to what they actually said. Here's Jefferson's letter to William Jarvis, dated 1820. You seem to consider the judges as the ultimate arbiters of all constitutional questions. A very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. It's exactly what's happened, ruled by a few. Now, what has happened is exactly what Thomas Jefferson warned us against, of what the federal court system has done, continually robbing the states unconstitutionally of the powers of government delegated to the states by the Constitution of the United States. Now, this enables the judges to simply make law out of their own opinions and biases. That's what they're doing here. For example, the Constitution of the United States protects freedom of speech, but the courts have created a new right, the freedom of expression, they call it. There's no such thing in the Constitution as some supposed freedom of expression. They've perverted protection of speech into a protection for actions and behaviors, such as flag burning and nude dancing. That's not really speech. Then there's another one, the so-called right of privacy, supposedly discovered by the United States Supreme Court in the Constitution. They've made up this right of privacy, quote unquote, as the reason to place pornography and sodomy, which have been long considered immoral acts against decency and good order by the American people, to place these above the reach of the law. Then there's yet another one that they've made up, the so-called right to choose. There's no such thing in the Constitution as some supposed right to choose. The Supreme Court has invented this thing, and that has become a legal club to prevent the various states in our federal union from protecting unborn babies against slaughter. In 1973, when Roe v. Wade was passed legalizing the slaughter of our unborn, the Supreme Court struck down laws against abortion in every single one of the 50 states. Every single state had abortion outlawed, and the court just did away with them at the stroke of a pen. Richard John Newhouse, the editor of First Things magazine, wrote, "No other question cuts so close to the heart of the culture wars as this question of abortion. The abortion debate is about more than abortion. It's about the nature of human life and community. It's about whether rights are the product of human assertion or the gift of nature and of nature's God. It's about euthanasia, eugenic engineering, and the protection of the radically handicapped. There are a lot of things at stake here." Now, in 1992, the decision Planned Parenthood versus Casey, the U.S. Supreme Court abandoned its old tactics of trying to justify abortion by some supposed right of privacy in the Constitution, and instead put it on the basis of liberty. This is even more serious. This is really frightening. The court stated, quote, "At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life." Dear Lord. Notice that reality is now defined totally by the individual. The great God self reigns supreme. Any government by the people, according to a common moral code, is now rejected as, quote, majoritarian intolerance. This is a complete rejection of biblical thinking, folks, and a complete rejection of traditional American thinking about life. Now, when the judiciary creates these new rights, it promptly enshrines them in new case law. Then the judges judge legislation not against the Constitution, but against other court decisions. So what this means is the Supreme Court has become a law unto itself. In the 1997 decision, Bernie versus Flores, the Supreme Court struck down the Religious Freedom Restoration Act passed by the Congress in 1993. In this decision that deliberately rejected the will of the people that was enacted through the Congress, the court said that it has the supreme authority to define constitutional liberties. This is an arrogant power grab, nothing less, on the part of the Supreme Court. So now, liberal judges are striking down laws that express the people's moral convictions and calling these laws mere personal animosity. Judicial imperialism, judicial tyranny, that's what the Founding Fathers would call it, that's the proper word for it, is now threatening this nation's liberties. Folks, when we lose the moral basis for the law, we're in real trouble. That means we lose moral restraints on human behavior. There's going to be increasing lawlessness and chaos if this continues. It means the government is reduced to a traffic cop to keep people from crashing into each other as they live out their selfishness. Thirdly, the loss of a moral basis for the law means we no longer have moral debate. Issues are not going to be settled by principle anymore, but by power. Whoever's got the most votes and the most power. And lastly, the loss of moral authority in the law means we've lost the rule of law. We're reverting to arbitrary human rule. You see, if you don't believe there's any God, and if you don't believe this Bible has binding authority, and if you don't believe the Constitution of the United States, which comes from this Bible, has binding authority, then, folks, anything goes. Then it becomes a matter of who has the most power, the most votes, the most money, who can force their will over the wills of other people. You have a disordered and increasingly chaotic society when that happens, and that, my friends, is where we are headed unless this nation experiences a real turnaround.